It's April, the birds are singing, the azaleas are blooming, and somewhere right now, a divorcing couple in North Carolina is making a very expensive tax mistake they have absolutely no idea they're making. Hi, my name is Connor Green and I'm an attorney at Cape Fear Family Law, and today we're talking about the intersection of two of life's most miserable experiences, tax season and divorce. You're welcome. Here's what you need to know. The tax decisions you make during your divorce, especially right now before April 15th, can have consequences that ripple through your case for years. Let's walk through the big ones. First up, filing status. Do you file jointly or separately if you're separated but not yet legally divorced? Here's the thing. If you're still legally married on December 31st of the tax year, you can still file jointly. And in many cases, filing jointly saves both of you money. But, and this is a big but, filing jointly also means you are both legally responsible for everything on that return. Everything. If your spouse hid your income, underreported something, or made a mistake, you signed it too. If your divorce is contentious, if you don't trust your spouse's financial disclosures, or if you suspect there are issues with their reported income, talk to your attorney and a licensed CPA before you sign that joint return. Filing married, filing separately often costs more in taxes, but it protects you from your spouse's tax problems. In a high conflict divorce, that protection is worth the extra cost. And the kids. This is where things get spirited. Under federal tax law, the parent who has physical custody for the majority of the year generally gets to claim the child as a dependent. That's the default rule. However, and courts deal with this constantly, both parents can agree to alternate years, or the non-custodial parent can claim the child if the custodial parent signs IRS Form 8332, waiving their right to exemption. What we see go wrong. Parents who haven't finalized their custody arrangement yet just both claim the kid, and then the IRS sends both of them a very unhappy letter. Don't do that. The IRS has computers, they talk to each other. Get this in your separation agreement or parenting plan so that it's clear who gets to claim the child and in what years. Okay, this one surprises a lot of people, and it's important. Before 2019, alimony was tax deductible for the person paying it and taxable income for the person receiving it. That created a real economic incentive to structure settlements with alimony. That changed. For divorce agreements signed after December 31st, 2018, alimony is no longer deductible for the payor and no longer taxable for the recipient. This has enormous implications for how alimony is negotiated. The old tax math doesn't apply anymore. If you or your attorney are still thinking about alimony the old way, you need to update that. This also affects mediation and settlement strategy. When attorney structures deals around alimony versus a lump sum, the tax treatment matters. Make sure yours understands the current rules. Here's a genuinely good piece of news in the middle of your divorce. The home sale exclusion. Under federal tax law, if you've lived in your home as a primary residence for at least 2 years of the last 5, you can exclude up to $250,000 of gain from the sale if you're filing single, or $500,000 if you're still filing jointly as a married couple. Why does this matter in divorce? If you and your spouse sell the marital home as part of your divorce settlement, you may be able to exclude a very significant chunk of the capital gain from taxation. Timing matters here. Talk to a tax professional about when to sell and how your filing status affects the exclusion amount. Done right, this can save you tens of thousands of dollars. One more note for 2026 specifically. If your investment accounts or retirement accounts took a hit in the last month, and many have, given the uncertainty around the market with the Iran conflict, that has tax implication for your divorce settlement. If you're selling investments as part of equitable distribution, the timing of those sales affects capital gains. If accounts drop significantly, you may be selling at a loss, which has its own tax treatment. Again, your family law attorney and your licensed CPA need to be talking. These are connected conversations, and too often people treat them as separate. Okay, let's do a quick recap. File status decision. Don't default, think it through. Kids exemption. Put it in writing. Alimony. The tax rules have changed. Home sale exclusion. You can save a lot if timed right. And investment accounts. Document everything now. We know this is a lot, and none of it is the reason you thought you'd be spending in April. But Cape Fear Family Law handles exactly this, the financial complexity of North Carolina divorce, not just the legal forms. If you need a consultation, the link is in the description below. I'm Connor Green from Cape Fear Family Law in Wilmington, North Carolina. Thanks for watching.